Welcome back to Winning Isn't Easy. Now, I've got a question for you. What mistakes do you see people make when they're writing their will and they're disabled? Or in the same scenario, what mistakes are they making in estate planning and they're unable to work that you want them to avoid?
Okay, so the first big mistake that everyone, whether disabled or not disabled, needs to know not to do when it comes to a will is don't make handwritten changes on your will after it's executed. You can't cross things out and then that invalidates it.
But that happens in the movies all the time.
It happens in my office all the time, believe it or not. But it's not, you can't do that. So if you need to change your will, it's as simple as picking up the phone and calling the attorney that drafted it for you. To tell them I need to take this person out and put a different person in or something like that. But you don't want to cross things up. The other big one.
Some cynical people are going to say, well, that's just a way for the lawyer to make money, right?
I don't know. You can copy it off into your Microsoft Word and make the change yourself if you'd like to, but
Okay.
don't handwrite it. You need it to be any changes. The point of it is that you don't want John Smith to find your will right before you die and cross things off, and no one will know whether you made that change or not. So you have to make the change in the same way that you created the original will. So it doesn't have to be the same lawyer. You can go wherever you want to get the change, but it needs to be executed in the same way. So two witnesses and a notary need to be there to sign that you made that change. So there are ways that you can make a quick edit to a will without having to re-execute the whole thing, but it's a different document that gets attached. So don't handwrite your changes. The other one is if you use a DIY template for a will, it's not 100% off. I mean, all the lawyers are going to be mad at me for saying this, but it's not 100% off limits that you can't try to do it yourself. But if you're in a situation where you are caring for a loved one who's disabled, or you do have a disability, or the risk that you might have a progressive disease or progressive illness later, you really want to make sure that you have a team of professionals that are able to look at things from every angle. So that's a big one because those DIY templates sometimes are they're very vague, and it leaves a lot of discrepancies for litigation later.
So in other words, you want a customized estate planning documents, including a will that addresses your current situation and what you would anticipate, particularly if you're having a progressive disabling medical condition. Is that right?
Exactly. Yeah. And you run risks that you accidentally make you miss something, and that causes big problems for someone down the road that you won't know for 10 years maybe, or for you. And as far as being disabled and mistakes that are made specifically with relation to people that are disabled or people that are caring for disabled loved ones when creating their estate plan, the biggest thing I would say is that you really want to think about the benefits that you might be impacting by what you're doing with the assets at the time, or the unearned income or earned income. So what you want is to plan your estate to maximize available government funding and services, and using your estate funds to supplement them. Because unless you're a billionaire, you probably don't want to use your own money to pay for stuff that the government's willing to pay for you.
So remind us what it is that the government is paying for that we don't want to pay for.
So we're talking about maybe medical coverage, like Medicaid. Sometimes people that are disabled are also eligible for SSI in addition to their SSDI or their other benefits that they might get from their employer or from any kind of settlement that they might receive. We're talking about Section 8 housing. Maybe some mental health services are available, but not only to the person, but to the disabled person's children as well.
Right. Are there any other mistakes that people need to know about when they're doing their estate planning and wills if they're disabled that we haven't already talked about?
Making sure you choose the right personal representative, which I kind of alluded to earlier, but just like the power of attorney and the healthcare surrogate, you want to choose a personal representative in your will that is someone that will carry out your wishes, and think long-term. So you might want to name at least one level of alternate if that personal representative is unable to serve. So if they get convicted of a felony, or they move to Australia or something like that and they're unable to do it, you want to really think all of that stuff through, because it's a long process to be a personal representative in most estates.
So I'm going to throw a curveball at you because I just had this happen in a case. Gentleman's in North Carolina, disabled, cognitive issues, collecting his Social Security and his long-term disability benefits, and he made his aunt responsible for his estate and gave her power over his assets. And of course, guess what she did? She cleaned out his bank account, and then she died. So now he's having to sue his aunt's estate. What happens in those kind of cases when that worst case scenario happens?
Yeah, it's hard to prove when it comes to a power of attorney situation, right? Because you can't sue the bank, you can't sue any third parties because they have the right to look at your power of attorney as if it's real, unless you show them in writing that it's not ahead of time. So you're stuck suing, I guess, probably his cousins in that scenario.
The administrator of her estate.
Right. And assuming that she has assets to collect on, right? So if she took all your money, I don't know what kind of money she had for herself, maybe a lot, but if not, you're looking for non-exempt assets that you can collect against in that estate, and you're wasting so much money. Sometimes it's depending on how much money she took, it's not even worth it to do anything about it other than distance yourself from that of the family. But that's an uphill battle, and that kind of litigation can go on for years and years and years.
And in the meantime, he's living in his car because she literally cleaned out the money he had gotten in his retroactive Social Security disability payment and the retroactive payment of benefits he got from the long-term disability carrier. So obviously, those kinds of mistakes can have catastrophic financial consequences.
There are some benefits, believe it or not, to appointing a corporate or a professional personal representative or a corporate professional power of attorney. It costs money in increments, but there is usually malpractice insurance bonds available. So at least if something does go wrong, you have someone that you can collect from. In those scenarios, it's hard to tell people if you can't trust your family. What do you do?
Well, unfortunately, you can use my client's example as an illustration of what can go wrong when you trust family members, and why it may be better to do exactly what you said.
Right. Yeah.
So let's take a quick break, and I'm going to come back and I got some more questions for you.
Sure.